So I'm a senior solicitor in the employment team at Debenhams Ottaway, and I was just going to talk to you today about some employment issues arising out of the COVID-19 outbreak, with a particular focus on the furlough scheme. So I was going to start by recapping the basics of the furlough scheme. I expect that many of you will have already been doing lots of reading around the furlough scheme and will know the basics, so I wasn't going to spend a huge amount of time on that. The main focus is going to be on the recent announcements made by the Chancellor in respect of the extension of the furlough scheme, and that includes the new part-time furlough option, and then we're going to finish off by looking at some problem areas. So it seems like a long time ago now, but people didn't really know what a furlough was, and very quickly it seems that that's all that anyone wants to talk about, and particularly to employment lawyers. It's important to understand that the scheme was designed to be relief for businesses who are severely affected by COVID-19, but it's not only for situations which would otherwise result in redundancy. So when businesses apply for the furlough scheme, they are not required to provide a business case. They are not means tested. So it is an option for businesses to use on a flexible basis to suit their individual needs. Periods of furlough must be taken in 3-week blocks. The scheme was already extended until the end of June, and many, including myself, were pretty certain that it was unlikely to be extended. So it shows what I know, due to the considerable cost. But surprisingly, it has been extended. So in terms of the cost, just to give you an idea, as of the 19th of May, 8 million employees had been furloughed by 1 million employers, with a cost of £11.1 billion, so significant costs involved. The portal for submitting claims opened on the 20th of April, and generally the feedback has been very positive. It seemed to launch very smoothly. The process for applying seemed to be very smooth, and payments were processed very, very quickly. So that kind of brings us up to date as to sort of where we are now and what's happening in terms of the furlough scheme and the basics. So last Friday, the 29th of May, the Chancellor announced how we're going to operate the furlough scheme moving forward. He talked about reopening the country, kick-starting the economy, and the furlough scheme being adjusted to ensure that those who are able to return to work can do so. So the headlines are that the furlough scheme has been extended until the end of October. Probably one of the most surprising aspects is that the full furlough scheme, that is with the government meeting the full costs of furloughed staff, has been extended until the end of June, so an additional month. The scheme is going to close to new entrants from the 30th of June, and this is something that hasn't really been heavily publicised and is easy to miss. So after that date, employers will only be able to furlough members of staff that have previously been furloughed under the scheme. Now, you'll recall that I mentioned that employees need to be furloughed on blocks of 3 weeks. So what that means is that if an employer wanted to furlough somebody for the first time and continue furloughing them after the 1st of July, they would need to furlough that member of staff by the 10th of June at the latest. Otherwise, they won't be able to furlough that individual moving forward. Now, the government has always indicated that there would need to be a tapering off of the furlough support, so that they always indicated there would need to be this gradual kind of weaning off of the furlough assistance. And that's going to come into place from August. So in August, the government will continue to pay 80% of wages up to the cap of 2,500. But from this month onward, employers will need to meet the national insurance and pension contribution costs. From September, that will reduce to 70% of wages being paid by the government, up to a cap of £2,187.50, and the employer will then need to pay the 10% balance up to the total of 80%. Likewise, in October, the government's contribution will reduce to 60% of wages, with employers paying 20%. Now, perhaps one of the most sort of interesting and exciting aspects that the Chancellor announced was that from the 1st of July, there's going to be a flexible furlough option for employers. Now, again, this is something that has been mentioned by the Chancellor on previous occasions. It was initially stated that it would come into play from August, so they've rushed it through 1 month earlier than previously announced. And from the employer's perspective, this gives a lot of flexibility. They're able to decide on what shift pattern will suit them in terms of the employee. The employee will be paid in full for any days that they actually work, and then any days that they don't work then can be claimed back under the furlough scheme. Again, the detail of the scheme has not yet been fully published, but again, it's widely thought that employers would need to enter into a written agreement with any employees that they wish to place on the part-time furlough, as employers would have already done in respect of the furlough scheme. Now, one interesting point as well, again, that hasn't been hugely publicised, it's likely only to be a problem for larger employers who have been rotating members of staff who are furloughed. But from the 1st of July, you won't be able to claim above the maximum number of employees that you've claimed for in any previous claim period. So just to explain what that means, so if you have been operating a rotation system whereby you may have had 50 employees that you wanted to furlough, but you're rotating them. So you're having 25 employees that you furlough for a 3-week period. You rotate those individuals back into work, and then the other group of 25 are then furloughed for the next 3-week block. What they're now saying is that after the 1st of July, the maximum number of employees that you would be able to furlough would be 25 employees. So you wouldn't be able to increase that amount to say 40 or 50. So again, a minor point that could have a large impact on particularly some larger employers. So what's the reaction been to these announcements? Well, I think it's been consistently very, very positive. I think there's a lot of relief that the full scheme has been extended, and that the tapering off is not very dramatic, and that the total scheme has been extended at the end of October. The Federation for Small Businesses said that the furlough and self-employed schemes have been a true lifeline for all those protected by them. Continuation, certainty, and increased flexibility will boost economic recovery and help us get through the turmoil created by coronavirus. So, largely very, very positive. Of course, the self-employed scheme has also been extended with some surprise there. So, the cost to the government is going to be very significant. So, what are some potential problem areas that employers are having to deal with at this time, dealing with including the sort of furlough arrangements and other arrangements they may have in place with staff? Well, the first problem is getting employees back to work. So as Eleanor touched upon, some employers have thrived at this time. They've realised that actually they can operate with employees working largely from home, and productivity hasn't been adversely affected. That doesn't work for everyone. Some businesses are desperate to get their employees back to work. For commercial reasons, those employees need to be in the office. Rather unsurprisingly, some employees are quite happy to be furloughed. They've quite enjoyed being at home, not doing any work and getting paid up to 2,500, and are very reluctant to come back. What a surprise. Some of my clients have met with just people just saying no, just refusing, people saying that they have health issues. Also, they are worried about the working conditions that they may have to return to. So there's lots of ways that employees are dragging their heels. So we're having to consider, what measures we can take. So the starting point will be what the contract of employment says. So the contract of employment and any subsequent variations that employers have agreed with their staff to either place them on furlough or to place them on short-time working, or to allow them to work from home. So you'll need to consider what those contractual documents say, and what does it say about your right to cease those arrangements. I think communication throughout this time, communication is always very important with employees, but it's even more important at the moment, particularly if employees are on a furlough or are working from home. So you need to keep them informed as to what's happening with regards to the business, how long the furlough arrangements are likely to continue, and when they may be able to return to work. Also, keeping them informed as to what measures they're taking, whether they're providing PPE, how they're going to allow them to conform with social distancing, when they do eventually have to return to work. For example, I've had some employers who are calling up employees on 3 or 4 o'clock in the afternoon saying, we want you back to work tomorrow. Clearly, that's not acceptable, and that's really going to get the employees back up. I think as employers, they need to appreciate that employees have been off work, whether that's furloughed or have been working from home. They need adequate notice to prepare themselves to return to work. They need to make arrangements in terms of their commute, their travel to work, childcare commitments, and just psychologically preparing themselves for that change, preparing themselves mentally for going back to work. So I think adequate notice is very, very important. But ultimately, employees do refuse to return. That does present a problem. And ultimately, there is a possibility that you could proceed with disciplinary action if an individual is unreasonably refusing to go back to work. But if there are genuine health concerns, if there are underlying disabilities, if that individual is shielding, or if any member of their household is shielding, if they have genuine reasons why they are unable to return, then employers will need to deal with that on a case-by-case basis. So the individual facts there will be very important. Another problem area that I just wanted to touch upon very quickly was just around holidays. So from the outset of the furlough scheme being announced, there has been some confusion around whether or not employees who are furloughed can take holiday. So the current guidance is that yes, they can, but the pay for any holiday period must be topped up their normal pay. So the employer would need to top up during any annual leave period. It is also sensible for employers to consider whether or not they should be either asking or compelling their employees to reduce annual leave allowance by actually taking some of their annual leave now during this period where the business may be going through a bit of a lull. It is possible for employers to serve notice on employees to actually take annual leave. Also, there has been an amendment to the working time regulations. So individuals who are not able to take their full holiday allowance due to the COVID-19 outbreak are able to carry over unused holiday for up to 2 leave years. So that's, again, some useful flexibility there. I was just going to conclude by touching again upon something which has been affecting some business owners. So obviously, with the impact of COVID-19, we're seeing very sadly some business owners passing away or becoming incapacitated due to illness. And this can have a huge impact on the running of the business if that individual does not have their affairs in order. So, for example, having a will in place. So do they have a will? Is it up to date? If there are any legacies under the will, particularly in relation to shares, are they allowed to do that under the company's articles of association or under any shareholders agreements? So, repeatedly we're finding problems with people trying to give legacies of shares under their wills when they're simply, this contradicts the articles of association and shareholders agreements. Also, in terms of any incapacity, powers of attorney will be very important to ensure the effective running of the business. There are 2 types of powers of attorney. There's one to deal with personal affairs. A lot of individuals who have a power of attorney in place may only have a personal power of attorney. Normally, it's that individual's spouse that's appointed to deal with their affairs in the event that they are incapacitated. But that individual may be completely inappropriate and incapable of dealing with the running of the business. So in that instance, it would be very useful and sensible to have a separate business power of attorney appointing another individual who is capable of running that business in the event that that individual is incapacitated for a period of time. And this can be so important because if the powers of attorney aren't in place, then the business is simply not able to function.